As the U.S. Supreme Court prepares to consider North Carolina's Moore v. Harper redistricting case, we're hearing about something called the Independent State Legislature Doctrine. Our next guest says this discussion includes a great deal of misinformation. Jeanette Doran is president and general counsel of the North Carolina Institute for Constitutional Law. And Jeanette, before we get into the misinformation, first of all, tell us, what is this Independent State Legislature Doctrine?
It's really just a new term for a part of the Constitution that's been around since the very beginning. It's called the Elections Clause, and it's at Article 1 of the U.S. Constitution, and that states that the time, place, and manner of electing members of Congress is to be set by the legislatures of the respective states.
And just to clarify, this is part of the federal Constitution that sets out the rules by which government operates, and it says that when you're setting these congressional elections and all of these rules dealing with them, it's the legislature within a state government that has that authority.
Absolutely. It doesn't use the word state. It specifically uses the word legislature. But it has an interesting second part of the sentence that says Congress can make laws sort of overriding what the legislatures do. And we could get into that a little later if you'd like.
All right, we'll talk about that when we get into the controversy. But first of all, so I mentioned this is the Moore v. Harper redistricting case. It's about North Carolina's congressional map. How does this Independent State Legislature Doctrine, or the Elections Clause, how does this factor in to this dispute about the election map?
Well, first, I think it's worth emphasizing to your viewers that the Elections Clause and this doctrine, which is just a new name for what's been around for a long, long time, would cover not just redistricting, but all sorts of election laws, things like curbside voting and ballot reporting and counting, things like that. So this doctrine, which is, again, just a new name for part of the Constitution, says, look, the legislatures are supposed to be controlling that, not activist state judges, which is what, unfortunately, North Carolina saw earlier this year.
And for folks who haven't been following this, what happened was the General Assembly, the legislature, came up with an election map, and the courts threw it out. So that's what the legislature is challenging, correct?
Yes. So every 10 years, following the census, North Carolina, like the other states, go through and they draw new maps. North Carolina, we also got one more U.S. House seat. So we had all of the seats that we had before, plus one more. They went through, they drew maps. The state courts threw those out. The legislature went back. They drew new maps. We had courts, again, state courts say, no, that's not good enough. And the whole thing started because we had a handful of activists in North Carolina who weren't happy with the maps that the legislature had drawn, even though the legislature had engaged in probably the most transparent redistricting process in the history of the state.
Now, as this case has proceeded to the U.S. Supreme Court, we've heard a lot of discussion about this Independent State Legislature Doctrine. You have already said a couple of times now, this is not something new. This is something that's been around for a while. But we've heard that this is new, novel, unprecedented, scary in some ways. What do you make of all of this discussion from the critics of this argument in favor of using the Elections Clause to determine this case?
Well, I think one of the things that they've done is they've latched on to the new name, Independent State Legislature Doctrine. Sometimes it's reported as Independent State Legislature Theory. But again, it is nothing but a new term for the way the Elections Clause in the U.S. Constitution has historically been interpreted. And we have cases and we have legal treatises going back to the 1800s. So it's nothing new, it just has a new label. And that came from some law review articles written by professors. So take that for what it's worth.
Yeah, and in fact, you've already pointed to this, but it's worth repeating that a lot of this criticism of this is that it's a novel idea and that it ignores precedent, and courts have never held the way that the North Carolina legislators are arguing in this case. You've documented a number of cases where this doctrine, not under that name, but in practice, has been treated as the precedent or the standard for many years.
Well, and I submit it didn't have a name like Independent State Legislature Doctrine because it was so obviously the law of the land for so many, many years. But we can go back to the Massachusetts State Constitutional Convention in 1820 when Joseph Story and Daniel Webster invoked what we would today describe most probably as Independent State Legislature Doctrine. They said, look, we don't need to have these types of restrictions in the state constitution for Massachusetts about what the state legislature can do about redistricting because that's already covered by the U.S. Constitution. And again, that's 1820, and we've had several cases, a great many, in fact, in the early 20th century, in which courts across the country relied on this concept, both with respect to the language in Article 1 about electing Congress members, and also comparable language that appears in Article 2 of the U.S. Constitution with respect to electors for president.
You've mentioned the activist judges and their role in this, but we really haven't gotten into the details of that. So the General Assembly came up with a map. The courts rejected the map. The General Assembly came up with another map. Courts rejected that map and substituted their own map, and in the process said that there were provisions in the state constitution that banned the type of map that the General Assembly put forward. Based on your reading of the state constitution, is there anything there that says the General Assembly couldn't do what it did?
No, which is why if one takes a look at that initial lawsuit, the one filed in state court in which these activists said, these maps are so terrible and they're unconstitutional and they violate the state constitution, they kept relying on these sort of vague general concepts. And when the state Supreme Court ruled in their favor, the state Supreme Court's opinion used these general notions of, well, elections should be generally fair, and then they left it to judges to decide what constitutes fair.
And in fact, I think it wasn't the word fair, but the word free, that all elections shall be free.
Correct.
Article 1, Section 10, it didn't even say anything about fair.
Correct.
Which you do see in some other state constitutions.
Correct, and those terms aren't interchangeable, which is why other state constitutions include the statement free and fair. Ours is free, meaning free from political intimidation. But one thing that is really clear in our state constitution, it's specifically laid out at Article 1 of the state constitution that the three branches of state government, the executive, the legislative, executive, and judicial branches shall forever be separate. Well, apparently the Supreme Court majority, and it was a 4-3 split, the majority said, yeah, well, they sort of glossed over that and decided to rewrite this language about what constitutes a fair, free election.
Well, we could probably talk for hours about how this independent state legislature doctrine plays out in the history and citing the various cases. But as the Supreme Court considers this case and makes a decision, probably sometime around June of 2023, we'll see the results, how should they be treating this doctrine, or if not the doctrine, the law that's tied to it that is based on the elections clause?
I think what we are most likely to see is a thorough analysis of the history going back to the founding, including, I'm almost without a doubt that we will see references to the Federalist Papers. We'll see quotes from the Federalist Papers, and then we'll see quotes from most likely we'll see quotes from some legal treatises that were published in the 1800s that discuss this concept. I think the court, whoever writes the opinion, the Supreme Court will likely walk us through all of that history, but start at the very beginning of it and try to explain why this is not a new or novel concept, because it really just isn't.
And what are the odds, in your perspective, that we will even see the words Independent State Legislature Doctrine? Do you think whoever writes this will reference it, or will they just ignore this and say that's for the legal professors?
Well, I think we'll see it somewhere. We will almost certainly see it in dissents. We may see it in a majority, we may see it in a concurring, but I think that it's more likely that whoever authors the majority opinion for the court will probably refer to this under its true constitutional term, the Elections Clause.
Well, it is certainly an important case, one that's coming up before the U.S. Supreme Court for oral argument soon, a decision expected late in the Supreme Court's term, sometime around the beginning of summer of 2023. One person who will be watching it very closely is Jeanette Doran. She is president and general counsel of the North Carolina Institute for Constitutional Law. Thanks so much.
Thank you, Mitch.